also have folks who are going to be joining at least one of IDAC's new subcommittees. We also have other stakeholders here who heard about the webinar and were able to join us live. And just welcome to everybody who's able to join us today. I'll remind folks, just if you're not presenting or asking a question, to keep yourself muted so that we don't inadvertently hear stuff coming through the recording that you might not want us to hear. For the folks who don't know me, my name is Sarah Jacobson. I go by she, her pronouns. I'm the Executive Director of the Public Defender Association of Pennsylvania. I also have the honor to serve as chair of the Indigent Defense Advisory Committee here at PCCD. As I think many folks here know, the IDAC has begun its work. We started forming subcommittees to work on the next phase of what the IDAC will do. We have 3 subcommittees. The data subcommittee's first meeting will be this coming Friday, October 4th. The standards committee will meet on Tuesday, October 8th. And the training subcommittee will meet on Tuesday, October 22nd. If you have any questions about subcommittees or meetings of subcommittees, please reach out to Jordan Lewis. Jordan's here with us, helping us with technical details here for this webinar, but she can also be reached at JOR Lewis, which is LEWIS, at pa.gov. And as the IDAC members know, the next meeting of the full IDAC will be on November 12th. 3 weeks ago, we hosted a webinar with Malia Brink, who spoke with us about the ABA's 10 revised principles of a public defense delivery service and the RAND's National Public Defense Workload Study. If you weren't able to join us for the webinar live, that recording is posted on PCCD's IDAC webpage. And if one of the folks from PCCD could put the link to that webpage in the chat, I'd appreciate it so that folks can find that easily if they're looking for it. Today, I'm pleased to welcome Jonathan Sachs and Kristen Staley, who are the first and current executive directors, respectively, of the Michigan Indigent Defense Commission. They're going to be talking with us about the history and priorities in building the MIDC, how the Commission developed Michigan standards, and how they grew their partnerships and the partnerships and funding that they have secured, and the current workings of the MIDC. We hope that hearing from John and from Kristen will help the subcommittees in their early work, and will also help the IDAC at its next meeting as the IDAC considers the questions of which standards should we be tackling next, and what process should we all decide to use to reach those standards. Let me tell you a little bit about both John and Kristen. I'll start with John. John's a career public defender. He served as the director of Michigan State Appellate Defender's Office since 2018. He started there as an assistant defender and served as its deputy director for 8 years, setting up projects involving early release of people serving jail sentences during COVID, reviewing the failed Detroit crime lab, and projects involving pre-screening convicted people for actual claims of innocence.
Oh yeah, you're right. How about that? That's cool.
Which a buddy of mine bought me.
Oh, so your names are. I'm wondering whether I want to
Thanks for staying muted. But John has roots here in Pennsylvania. He began his career in the Philly office as an assistant public defender, worked in majors, worked as a supervisor of felony trials at the Defender Association of Philadelphia, which is where I know John from, and really excited that John is giving us time here today to speak with us. Let me also tell you a bit about Kristen. Before becoming the executive director of the MIDC, Kristen served as the MIDC Central Michigan Regional Manager, where she oversaw compliance of MIDC standards and development of best practices in public defense across 12 counties. Before the MIDC, Kristen was the Deputy Director of the Michigan Council on Crime and Delinquency, which is a nonprofit dedicated to advancing effective policies and practices within the adult and youth justice systems. Kristen is the co-director of the Midwest Juvenile Defender Center and a member of the National Juvenile Defender Center's National Advisory Board. She's also an appellate clerk in Kentucky, and we're really excited to have both of them here speaking with us today. During the presentations, folks are welcome to, please do keep your computer muted unless you're asking a question. You can put a question in the chat. We'll address those questions at the end. Both John and Kristen have said that they'll take questions as they come. Also, so if folks want to come off mute and ask questions as you have them, feel free to do that. Or probably better use the raising feature to get our attention for sure. And again, like I said, we'll take any questions that are in the chat there at the end. With that, way too much of me talking because you didn't come here to listen to me. You came here to listen to John and to Kristen. So I'm going to turn things over to them. Thanks so much, John and Kristen.
Thanks, Sarah. Kristen and I decided that we would just do this chronologically. So I would go first for about half an hour, give or take, and then Kristen would go after that. Please interrupt us for questions. I may not see, I'm not that good at multitasking, so I may not see chat questions during my PowerPoint, so feel free just to jump in and ask questions. It's obviously good to have an interactive presentation, but otherwise we'll take questions together at the end as well. Thanks, Sarah, for the awesome introduction, and thanks for having me and for having us today. It's really gratifying to talk to the Pennsylvania folks about indigent defense reform, because as Sarah said, I started my career at the Philly Defender. It very much formed me as an attorney and is really near and dear to me. It's also wonderful that Sarah is chairing this group. She was clearly a rising star when I started at the Defender and already leading training programs and training investigation type coordination programs, and that Kate Cacciamani is the vice chair. I remember Kate there as well, who was just sort of this intimidating force who used to go to the cigar bars after court, and all the new lawyers really looked up to her. So with that, I'm going to get going on my presentation, which is the early years of the MIDC and the sort of dynamics that took place to get us there. And then Kristen will take over from me to talk about the implementation stages and where we are now. So let me quickly do the screen sharing and get started with that. I might just do it like this, if that's okay for folks. Oh, here we go. Let's try this. There we are. That's better. All right. So Michigan Indigent Defense, 2015 to 2018. And I'm going to start a bit before that with the lay of the land, just before things got going with the MIDC. So every presentation I ever do starts with the 6 amendments. I'm sorry about that. That's what always my strategy in Michigan when I speak to legislatures, when I do staff meetings. It just keeps us rooted with where we are and why we are doing what it is that we're doing. So the background in Michigan is in 2008, the National Legal Aid and Defender Association came in to do an evaluation. The title of the evaluation sort of gives you an overview of what they found and where things were. That basically the Michigan system was speed and savings overdue process, a constitutional crisis. They looked at 10 representative counties in Michigan so that it couldn't be accused of just looking at Detroit or just looking at rural areas instead of very representative sample. And they looked at the ABA 10 principles of a public defense delivery system. And I know folks from the last webinar are familiar with that. They concluded basically that Michigan was failing in all 10 counties, and a big reason for that was just the lack of spending. Michigan was 44th in terms of per capita indigent defense spending. So this report resulted in a lot of messaging, a lot of litigation, and a lot of sort of further reforms and actions as to what to do next. And the messaging resulted in what sort of stemmed from what does it mean if there's a failing public defense system? And the things that folks focused on in Michigan was first that we had convictions and imprisonment of the actually innocent. And there needed to be a result when the government came in and didn't have proper evidence, and when we had this dynamic. I often talk about the example of Derek Bunkley. I won't get too much into it because there's a lot to cover, but to make a long story short, he was a client of the office where I am now, the State Appellate Defender Office, and a really good example of what happens when there's inadequate counsel at the trial level in a complicated case. He's convicted of armed robbery and a shooting. He gets 17 to 32 years. It's a straight up identification, and what is not used at the trial level is satellite tracking evidence that would have showed him in a different location, and also social media evidence that would have showed him at a birthday party in a different location. When we talked to the trial lawyer about that, the trial lawyer said, I didn't get into that sort of stuff. I don't even understand email. And that's fine, but obviously that's not somebody who should be defending folks who could lose their liberty for 17 to 32 years. And so that for us was a really good example of what happens. And there's Derek Bunkley walking out of prison, but he shouldn't have been there for 2 years before his appeal. And it's an example of what happens with issues with improper and inadequate counsel because of a broken public defense system. Here was a lack of experts and a lack of investigation. We talk about the human and financial costs of sentencing errors that we have from a broken public defense system, more common than the actual innocence cases. This is Andre Brown. He was a client of mine. And this is how we were able to portray Andre Brown to the court. He's a Desert Storm veteran. He's somebody who suffered massive post-traumatic stress disorder, and he's somebody who we were able to show he had a support network. He was in touch with folks he was in karate class from since 5th grade, one of whom was a police captain, one of whom was a small business owner, and they would be his support network when he was released. He got a new sentencing hearing because there was a small error in sentencing guidelines, but the point is this wasn't the Andre Brown that the prosecutor or the court saw. The Andre Brown they saw was somebody who had an on-again, off-again bad relationship, and he had a very bad night where he came close to overdosing and ended up burning down the door of a house they shared, and he and his on-again, off-again girlfriend shared, and he pled guilty to arson. And because there was a sentencing error and because the court didn't see this side of Andre Brown, we were able to show this is who he is, and he was immediately parole eligible after a new sentencing. And we feel like a proper public defense system, this wouldn't need to happen on appeal. The other sort of messages that came out from that Race to the Bottom report was the denial of counsel, wholesale denial of counsel for misdemeanor offenses in Michigan. Folks would show up in court. They would speak to somebody who would say, listen, if you go in front of the judge, you will walk out of court today, you'll get some fines, you'll get some probation, you'll be fine. And that person didn't even realize that the person that they spoke to was actually a city solicitor and not a defense lawyer, not someone who was representing them. And they would walk out of court. That part was accurate, but not knowing that if they failed a drug test later, or if they didn't report to their probation officer, or if they got a new arrest, they could get a jail sentence for that. So there was a wholesale denial of counsel for misdemeanor offenses and the consequences there. Excessive caseloads was something else that came out of the report. In some of the busiest courts, such as that in Detroit, folks were handling thousands of misdemeanor cases in a year and sometimes over 100 a day. And then under those circumstances, the best, most well-meaning attorneys were not going to be able to represent their clients. So with all these dynamics at play, and these aspects illustrated by the NOADA report, two big things happened. The first was the ACLU stepped in with a lawsuit focusing on a few counties and the inadequate representation there. And then the second was Governor Snyder at the time appointed an advisory commission on indigent defense made up of different stakeholders in Michigan, judges, indigent defense people, prosecutors, court administrators, and other experts to look at the state of public defense in Michigan. And they had three primary findings. First, that Michigan's counties offered an uncoordinated 83-county patchwork quilt of public defense systems. There was no coordination, there was no best practices, and not only would it be different in 83 counties, but sometimes in one courthouse, there might be a different public defense system in the two courtrooms next door to each other, depending on a judge's preferences and how they did it and how they assigned counsel. The second was the advisory commission found no data or transparency to show if taxpayer dollars are spent efficiently or effectively. We just had no idea what things even look like in Michigan with the public defense system. And then the third is there are no statewide standards to define how public defense should work and what is constitutionally adequate counsel. I know these are very similar dynamics in Pennsylvania, so hopefully our journey can provide some good guidance here. So as a result of the lawsuit, of the ACLU lawsuit, the NLADA report, and the advisory commission findings, the next step was the Michigan Indigent Defense Commission Act, which passed in 2014. And the MIDC Act had four main pieces, and those pieces responded directly to those conclusions of the advisory committee. First, that data needed to be collected and compiled to review indigent defense. Second, that minimum standards needed to be created. But the important thing is those minimum standards needed to be meaningful. When the MIDC started, we found that a lot of minimum standards in a lot of places were merely words on paper, and they were aspirational and they were nice, but they didn't really have any impact. And the goal was to create minimum standards in a statutory scheme that then would set up a scheme for different counties and municipalities to put together compliance plans to meet those standards. That was the third big piece of the act. And then the fourth piece is the state would then fund those compliance plans. So it was one part gathering data, one part setting standards, one part working on compliance with those standards, and then finally funding that compliance. And that was the way that would work. And the theory was if the state would fund it, then everyone else would go along. It took a long time to get there and for people to start believing that the state would actually fund it. But the framework wasn't that anyone would be punished. It is rather that once standards are in place, the state would support the compliance with those standards. So I was hired as the first executive director in early 2015. And the first thing to do was to set up a staff for the MIDC that we would do our work, we would report to the commission, and the commission would then move forward on adopting standards and getting compliance plans moving and all those pieces. So the framework we put together was to have sort of three core units of the staff. One was training, outreach, and support. And the goal was perhaps in the future, this would be someone who would work on uniformed defender training. But in the present, the goal of that unit was to figure out outreach and support so that different counties could and different courts could figure out how to meet those minimum standards. So to do that, there were regional managers from throughout the state. We divided Michigan into 6 different regions, and we hired one regional manager for each region to work with the counties and municipalities there. And there was a policy associate to work on how to comply with those standards. And I'm pleased Kristen is following me. She worked as a regional manager in those earlier days and actually initially as a policy associate there. The second main division was research. We took it very seriously, the findings of the advisory commission that nobody knew what was going on with public defense in Michigan, and we had to figure it out. So one of the first hires was a PhD in criminal justice issues, not a lawyer at all, who could help us get around these research questions. His name is he's Dr. Jonas Siegel, and he's still there now, and he has one staffer. And then the third piece, of course, was just administration. We needed, like any agency, finance, human resources support. So that was through a state administrative officer. So that was our initial staff that we built up to about 15 people over the first few years when I was there. So the first job of that staff, beyond just setting up the office, was to put together a first set of minimum standards. And our goal, we had a few goals in these standards, in putting together the first standards. But the first set of goals was really that these standards would survive scrutiny, that everybody would realize that it was what was needed for public defense. So with this in mind, the standards had to be bulletproof. Nobody could say, oh, wait a minute, I don't agree with that one. That doesn't make sense to me. We should do it this way instead. Or what's the authority for that? Or other states don't do it that way. We had to make sure it would survive that sort of scrutiny. So for that to happen, we wanted to make sure that the standards were supported by data, and that's where the research director came in, that they were constitutionally mandated if possible. They weren't all, I mean, they all came stemmed to the right to counsel, but that perhaps they were separately constitutionally mandated, or else, if not constitutionally mandated, at least required by the MIDC Act. We wanted these to make sure that the standards would withstand scrutiny. The other thing that we wanted to do with our standards was we were familiar with the research that the best indigent defense providers are public defender offices. And this, of course, was my bias. I'd come from Philly. I'd come from the State Appellate Defender Office in Michigan, 2 model defender offices. And we knew, like I said, the studies, we wanted standards that would generate public defender offices. This is a photograph from a recent holiday celebration we had in my office with some of our clients who went home, some of our staff, and we feel like that public defender offices are the way to move forward on public defense and to have best practices all around. So those were the goals of those standards. So with that in mind, our first step was the data collection. So we spent our first several months, and actually this is February 2016. So I started in February 2015. The first year or so was spent starting to figure out ideas for the different standards, building the staff and building the office, and starting the research. So by February 2016, we were able to publish the first research report, which was Michigan's first ever comprehensive snapshot of what public defense looked like. What did indigent defense look like in 83 different counties and then in several dozen municipalities as well? This was the first ever survey of local court systems. And based on the results of that survey, we were able to put the standards together. So standard 1 was education and training. And education and training stemmed from our data that almost all of Michigan had no training requirements whatsoever to practice public defense, to be sitting next to somebody at a table whose liberty might be at stake. No training requirements at all, except for the handful of counties there in yellow and one in red, and even those had nowhere near enough training requirements. Michigan is different from Pennsylvania. There isn't even required CLE in Michigan, and we felt like that wasn't sufficient for indigent defense. The second big standard was, the second standard was the initial interview. And here our data found, this is the NOADA report, that all too often initial interviews with clients took place in the courtroom in one county. This was Wayne County, where Detroit is, in an area that was colloquially called the bullpen, a cell behind the courtroom, before a hearing was held. And that was the first time someone would often meet with their lawyer. It was not a confidential space. There might be 9 other people in that holding area. And that was the first time somebody might get a plea bargain or would go in front of a judge, and certainly no forum to talk about pleas, to talk about potential investigations. So this was well documented from our survey. We knew that 26% of courts had no confidential space, and either courts or holding facilities, and 9% had no confidential space in either. So this was a standard like the training standard, where we were able to point out data. We were able to point to the right to counsel as a constitutional justification, and we were able to say, look, this is required by our statute. The third standard was investigation and experts, tied completely to straight up right to counsel, right to present a defense case law, obviously a constitutional obligation to present an expert on defense. That's the Aki decision. And so we talked about that, and that's the Derek Bunkley example that I gave. Too many people who had been exonerated in Michigan because of defense attorneys who just were not resourced to properly investigate that arrest and those circumstances. The fourth standard was counsel at first appearance. And here again, this was based on the data we collected. Only 6% of district courts in Michigan required attorneys to be present at both the bail hearing and the arraignment, despite the documented importance of counsel at those stages. We had language in the MIDC Act that required counsel from the first stages of appointment, so we were able to have a statutory justification. And then also there was a U.S. Supreme Court case that gave us some benefit here. It's slipping my mind now, but some justification here as well. So those first four standards were important to us because they were all rooted in the data we collected. They were all rooted in either the Constitution or our statute. They all had very important public policy considerations that made complete sense. And I had the slide about the public defender office. They all were standards where one way to comply with them was to build a public defender office. A public defender office would have confidential meeting space. It would have a team of lawyers who could meet with people who are arrested quickly. It could run training programs for continuing legal education. So the standards were very strategically chosen. First, based on data and based on them being bulletproof, but second, so that the compliance would increase the quality of public defense, not just by virtue of meeting the standards, but by virtue of setting up defender offices. So what happened next? The commission adopted those standards, and then our statutory scheme would send those standards to the Michigan Supreme Court for approval, and things would get going with compliance. One thing that then happened in Michigan that I hope would never happen in Pennsylvania, and my big advice is to make sure that state constitutional laws really scrutinize any statute, lawyers scrutinize any statute before it's passed, because what we didn't expect and anticipate is our Supreme Court found that after standards were submitted, that the MIDC Act raised serious separation of powers concerns. The good news is they didn't strike down the MIDC Act or the scheme or anything like that, but what the Supreme Court did was tentatively approve the minimum standards, but they said on condition that the statute changed to fix separation of power concerns. So without going too much into the weeds, the short story is an executive agency was regulating the courts, which was problematic. And it needed to be changed so that instead an executive agency would work with the funding units, the counties and the municipalities. Thankfully, because of all the dynamics I talked about in the beginning of this presentation, the lawsuit, the studies that everybody bought into that showed the problems with public defense, and the issues that had resonated with actual innocence, with large caseloads, with sentencing errors, there was a uniform consensus to fixing these issues. And just as there was for passing indigent defense reform, there was a uniform consensus to fixing the issues with the MIDC Act. So the legislation was amended, and it slowed the Supreme Court order, put things in a holding pattern for a few months. But ultimately, the MIDC Act was amended to resolve those separation of power concerns, and the new MIDC process, and Kristen will talk about this a bit more, so I'll just quickly touch on it. Instead, an agency called LARA, the Licensing and Regulatory Affairs Agency in Michigan, would approve minimum standards. The different systems, the counties and municipalities, no longer the courts, would submit compliance plans, and then the MIDC would either approve or reject those plans. And when those plans would be approved, the MIDC would seek the state funding, and the state would then fund those plans. That was the new statutory scheme after the Supreme Court order, and based on those same four minimum standards. So What happened then is Laura, Licensing and Regulatory Affairs, approved those first 4 minimum standards. That was in the summer of 2017. And the next step was to disseminate this information. That was done in this booklet you're looking at. And our regional managers, our 6 staffers, basically then spent their lives going from county to county with their minimum standards and explaining that compliance plans would be needed for those standards. What we did to help with that compliance, to help with next steps, is we published white papers to accompany the first 4 minimum standards. We said, here's what those standards are. Here's why they are important. Here is how we are going to measure the compliance with those minimum standards. And here are some suggested models for complying with those standards. And then the commission published a second booklet in tandem with those standards to suggest recommended delivery system reform models. And the idea here, and this gets at the public defender piece that I mentioned earlier, the idea here is that, yes, somebody could meet these 4 minimum standards piecemeal. They could continue with the current indigent defense system and just add training to it, add counsel at first appearance, add a system to have lawyers meet their clients in confidential spaces, and add access to experts and investigators. But that wouldn't be the best practice. The best practice would be to have full-scale delivery system reform models that would meet those standards. And so the MIDC suggested 2 potential delivery system reform models to meet those minimum standards and be part of those compliance plans. The first would be new public defender offices to meet those plans. And the second would be what we called a managed assigned counsel system. And this would be an assigned counsel system that didn't just appoint lawyers and leave it at that, and that have a court administrator manage things. It would be an assigned counsel system that would include access to experts and investigators. It would include potentially social work support. It would include proper hourly wages for those attorneys rather than ways to pay them that were not the best way to pay lawyers practicing indigent defense, and it would include maybe more controlled caseloads. So the commission really pushed either new public defender offices or managed assigned counsel systems to meet those first 4 standards. So the next step was for the regional managers to work with all the different systems and collect those compliance plans, and meanwhile, to get working on the next set of minimum standards. So I'll talk about each of those processes in turn. The next set of minimum standards, the same things as I talked about before, based on data, based on a statutory scheme, but these were the standards that the commission knew would be a little more controversial. And they wouldn't be the same standards that everyone would look at and say, oh, we agree with that, let's do it. These would be some that would increase the controversy, that would raise some scrutiny. But the hope was, with the first 4 standards already out there, compliance plans being put together, and the state making a funding commitment, that the MIDC would be in a good place to move on the next set of standards. So the next set, and when I left the commission in 2018, they were proposed, they weren't yet adopted, would be independence from the judiciary, so that public defenders aren't answering to judges, they're instead just answering to the people they represent. The workloads of public defenders, the qualifications for defenders in terms of types of clients and cases that they would represent, and economic disincentives or incentives. And these were held as not part of the first set. First of all, because, as I said, some of them, like independence, were more controversial, but also because they cost a lot more. Economic incentives and disincentives to properly pay defenders and assigned counsel and to properly regulate workloads, we knew would be a major investment by the state, and a necessary investment, but maybe not what to ask for in year 1. Instead, year 1, we would start with these first 4 standards. So these were the next 4 proposed, and as with what we did with the first 4 standard, we needed research and data to show the need for them. So we put together 2 new research reports. The first was a caseload distribution in Michigan's assigned counsel systems. This went to independence of the judiciary. And it's not a very exciting title, but what this report showed was basically a complete patronage system in lots and lots of counties, where cases were assigned, maybe 80% of cases were assigned to 15% of lawyers in that county. And one judge's courtroom, a high volume courtroom, might just use 2 lawyers who happen to contribute to that judge's political campaign. So we were able to demonstrate that a system that was not independent from the judiciary where was uniquely problematic. And then the second report went to issues like payment and workloads, and it just demonstrated the attorney perspectives. We had focused on clients, we had focused on systems, but we had never yet really surveyed attorneys before. So we did our first survey of attorneys who were either public defenders or assigned counsel, and unsurprisingly, we found that they were crushed by their workloads and they were paid nowhere near enough. So these 2 reports then became the basis for the next 4 standards. Meanwhile, the first compliance plans were submitted. The MIDC staff were able to get together 134 different plans from counties and municipalities that were then turned over to the commission, who reviewed them along with recommendations from staff and ultimately approved them. Those plans included 15 new public defender offices, including some regional offices, thousands of new continuing legal education credits. And for the first year, the funding commitment was $86 million to meet those plans. So it was a successful process with those first 4 standards and with that compliance there. So at this point, I think Kristen will take over to start talking about what's next. If anyone has burning questions, I can take them now, or otherwise we can wait until the end of the presentation.
I did see that there was a question posed in the chat there. Sarah put one up for you, John.
Oh, great. Now that I've stopped screen sharing, I can look at that. So let's see. All right. Pennsylvania's Indigent Defense Commission has staffing support from smart, hardworking staffers who work for the Commission on Crime and Delinquency. It doesn't have its own executive director or other staff. What kind of staff would you recommend for work? So good question. And I know Kristen will have a full org chart coming up, but basically, I think it's critical. I think it's awesome that the Commission on Crime and Delinquency are turning over so much energy and employees to help out with it. But I think there's no question there needs to be a full-time staff. What I just described was a 3-year process that accomplished a ton, that culminated in an $84 million funding commitment and a movement towards all those new defender offices. And there's no way that would have happened if there weren't 6 regional managers who were working with all the counties. There wasn't a research director and 1 staffer who would generate all those research reports that I showed, and there wasn't administrative staff to keep it going. So I would say, as an initial measure, easily 10 people. That's I think what we had for the first few years. 10 people, and then growing as things get more ambitious and more stuff happens.
John, I have one other question. It's sort of, this is Sarah again. It's sort of a follow-up. I think I heard you say that the initial appropriation was somewhere around 15 and you all grew it to 86 million in the first 3 years. What do you, how? Can you talk a little bit about how that happened?
Yeah, so very good question. And that purely happened, one part our statutory scheme and one part messaging. So it wasn't even 15. It was about 1.5 million, growing, I think, to 2.5. And that was just for MIDC operations and those staffers that I talked about. That was the initial commitment. But we were able to do 2 things. We were able to say, first of all, here's a statutory scheme, and the statutory scheme says, get us compliance plans, and then the state is going to fund it. And everybody said, well, we don't believe you. That's nonsense. This is going to be an unfunded mandate. And we said, well, okay, but what do you have to lose? Because the statute is very clear that if the state doesn't pay, the counties don't have to. These minimum standards become meaningless if the state doesn't actually provide the funding commitment. So people sort of took a giant leap of faith and submitted the plans, even though all we had was the statute to point to. And then what happened, and I have the commission to thank for this. This was the commission who accomplished this, not our staff, because it is so, I can't emphasize enough, and I know Kristen will be talking about the members of the commission. I mean, our commission was very politically plugged in from both parties and stakeholders from throughout the criminal legal system. And they carried real heft with the Michigan legislature and with the Michigan executive at the time, Governor Snyder. And when the commission said, listen, this is the $84 million it's going to cost to comply with these first four minimum standards. And remember, everyone, here's the statutory scheme that requires the state to pay this $84 million. It came through. That was the executive recommendation for the budget, and then the legislature passed it. So it was one part a statutory scheme that guaranteed it, one part the counties that were willing to buy in and submit compliance plans, even though they didn't believe it would happen. One part, the messaging that I talked about that people bought into, the innocence, the sentencing errors, the workloads, all those pieces. And then one part, a commission that had the political heft to really push that through.
Yeah. And Sarah, I will talk a little bit about how we've evolved from year one. And so the big jump is that money went not from operations, but to the local systems, right? And when we talk about the granting process and and John mentioned 134 grants, that's why the money jumped so high, right? From the first couple of planning years until we actually got plans coming in and people buying into the system. So I'm just gonna, unless there's other questions, I'll stop in case there are. But I'm gonna jump into my part here so we can kind of see. Okay, 1 second here. And thank you all again for having us both. This is really, I agree with what Jonathan said. It's really fun to see from our side of things and watch other states grow into a public defense commission or Indian Defense Commission. I mean, it really has significantly changed the way our state functions, and I'll show you a couple of towards the end of this slide deck here. There's a handful of stats that we've been able to collect and just to really truly show the impact across the state. So I'm just going to go back quickly to, I know Jonathan went over a little bit about what our MIDC Act and how it was created, but our act is extremely detailed. If any of you haven't already taken a look, if you want to take a look, there's a link here on my slides, but also this is our citation. And it is really our guiding principle. We do not have administrative regulations. It is jam-packed with very detailed process steps, things that we have to get done, many very detailed mandates that our commission and the staff that supports the commission has to get done, including things that you see here, developing and overseeing implementation of the standards, administering grants to support the local implementation. If a local system needs the money, it's not guaranteed that you would get a grant every year. We monitor and ensure compliance. So it's not that we just hand out money and we make policy, but we also are out in the field and making sure that things are actually working the way that they're supposed to. We are mandated to collect and analyze data from the money and the funding and the support that is being spent out and across the state. And one of my favorite parts is that we're mandated to encourage best practices. So that means that we're given the flexibility to provide innovation and to push forward and not just stay put in terms of like, these are our standards, that's all we can fund, and that's all that we can support. Public defense, criminal defense, in the criminal legal system, there's a lot of innovations and a lot of really great research out there. And, this allows us to be very flexible. And it's not just the commission and the commission staff that have mandates, but it's also the local systems themselves. So our local partners, which they are definitely partners, we could not be doing this without help and support from 134 local systems out there that, and when we say local systems, it's those systems that fund the court units. So it's mostly counties, it's some cities, and it's even some townships too that we have. They're required by our statute to actually work with us, to cooperate and to participate. Jonathan is completely right. I was one of those regional managers who, in the very early days before the grant started, that was out really hustling, working with all the local administrators, court administrators, judges, local council. People really truly did not believe that we were here. Even when I would say, hey, we're here, we're going to help you and provide you funding. It took a lot of effort and a lot of belief and trust to get folks to do what the statute says, is that they must submit a plan, even if they weren't going to be receiving any extra funding, but they had to submit a plan to show the state, to show our commission what it is that they're planning to, how they were planning on meeting the standards that were put into place and were mandated through this MIDC Act. And we also maintain in the statute that every local system has to maintain what we call a local share. And so it's defined in our statute by, we don't allow unfunded mandates in our state. So if the state of Michigan is telling a local county to do something, and they're not already funded to do it, the state has to pay for it. So that really truly helps quite a bit. And so this comes from while local systems were all providing some type of public defense, many were really, really underfunded. Some were doing better than others, of course. We did, before our act existed, before the MIDC existed, we did have 8 counties that had public defense offices across the state, and those were really great models to start off with, and obviously really good partners and always have been to this day. And so, some places invested in it more than others, but they had to maintain the equivalent of an average of 3 years of funding prior to the enactment of the MIDC Act. So prior to 2013, when the act was came into place. So some places, annually, it's around $38 million that every local system has to keep. And I'll show you a chart that makes it a little bit easier to digest. And then again, local systems have to actually comply with these standards. So once a plan is approved, they actually have to do the work. And we do have in this act, carrots and sticks, right? So the carrots being the funding that we could provide through our grants, the training and the opportunities. But the act also allows us and gives us very, I would say, big authority to come into a local system and truly take over. I'm very thankful that we have not had to do that and that we've not come to that part. But in early days, it was tough. There was lawsuits and we've had mediation with local systems and all sorts of things. That's not necessarily the case now, but it was tumultuous in the beginning. So with these mandates that we have, this is what it felt like. So, use whatever cliche that you want, whether we're building the plane while flying it, by drinking from a water hose, whatever, riding a bicycle while riding it, whatever. We heard it all the time. And that's what it felt like. Once we got, staff built up and our standards were enacted and, all the things that Jonathan was talking about, we actually had to do the work. We had to build all these new systems. It's not just new systems locally, but it's still a brand, somewhat young agency in the executive branch. We're something that is brand new to state government. We had to, actually secure support and resource. So support, building local support, state support, stakeholder support, but also money. We needed to actually get this done. And Sarah, I'm glad you already started asking those questions about how did we actually get this done. And I'll talk a little bit about it in a second. We also at the same time had to make sure that we had all of these standards and implementations, and how do we actually make sure that people are complying? What should we be looking at? How do we actually manage grants? How do we get out there and do this? And how do we actually plan for this to stick around and this not just become a one-shot, influx of, $80 million one time and that's it. We had to make sure that like whatever we're doing in the beginning is going to set us up for long-term success, because this is too big of an experiment to fail, right? So that's how it felt. It's still many days it still feels this way, but it's there's a lot to do. And we really truly could not have done it without these strong partnerships. Again, I know Jonathan mentioned, but I know that your commission is also very, very large, or your committees, and it's wonderful to see. I think having broad support from all stakeholders in the legal process, whether it's judges, prosecutors, defense attorneys, people who have been system involved, all of the local systems that are impacted, our state budget office, our legislature, everybody who actually has a stake in this needs to be a part of it and at the table making these decisions and actually kind of just hashing it all out, because this is something that we're constitutionally mandated to do it. There were lawsuits pending. We don't want to go backwards. But it also is about the operating staff that we have. And again, great question, because every single day, I still think that we are constantly understaffed. So right now we have 18 staff. We have a 19th member of staff who is grant funded, but is not full time. And this, as you can see, it is evolved and we've grown. I've been very fortunate to actually be able to grow the staff in the past couple of years. It's still, frankly, not as much as I'd like. Every year I try and put in a couple more FTEs if I can squeeze it out. But it definitely gets overshadowed by the amount of funding that gets sent out the door and into the local systems, which is good because that's where the work is being conducted. We don't represent clients at our office. We are not a law firm. Our regional managers are licensed attorneys who have extensive background in public defense work. We have a grants team of a grants director who oversees the administration of funding, and with 2 analysts on the team. We still maintain our research staff, who is very critical to ensuring not just that we can still maintain support for the current standards that we have, but that they're actually worth it. And so that team helps immensely when it comes to asking the legislature for help or for helping with local systems, really just analyzing what we're doing. And again, we have legislative and states director, and we've kind of moved away towards splitting the tasks. So we have there's a training director on staff, because we have begun to actually have statewide trainings that we host, as well as we organize and help support locally. We have a lot of training vendors in our state, as well as local systems that some, perhaps like Wayne County or some of our larger places, that have their own local training directors, but will open up their doors to having folks come and participate statewide. So we couldn't have done it, of course, with the internal support and the foundation, but one of the major things that we did was, this similar slide, but it's, we had to actually go back to the statute and say, okay, look, we have a plan that is required. We have a deadline, a statutory deadline to get things done. We have certain approved standards. We have to, receive a plan within a certain amount of it within 6 months, because the standard's been published. How the heck do we actually get this taken care of and get this done? So I'm going to walk through what this looks like, and the very quick, short deadlines of what we were forced to adhere to. And it, again, going back to the water hose, drinking out of a water hose scenario, that's why it felt like this, because we had 6 months to quickly realize that we need to get every single system to submit a grant plan, and then another 6 months to have all of our commissioners review them, but make sure that staff also can give it context from the local systems and the partnerships we've built. So it's a lot of learning curves for sure. And I can now successfully say that we have gotten to the point where we have our commission and our executive branch agency that houses us has fully approved 9 standards, which is all of the standards that the commission has submitted and authored. And it's amazing. And this coming year, literally actually today's our first day of the fiscal year. So that means grant dollars went out the door today. This current year is the year that we'll see the implementation of our final 2 standards that were approved, which is attorney workloads and attorney qualifications and review of counsel. Again, these were strategic. The way that we unveiled this to make sure that it wasn't while it was extremely hard to do and a lot of systemic change was happening all at once, we still attempted as best that we could to slowly roll out some of the standards. For example, the first 4 standards here: education, initial interview, investigation, and experts and counsel at first appearance, which we previously discussed. They were the first 4 standards, and we did not roll out a next standard, which was independence from the judiciary, for 2 more years. Now, of course, COVID happened, so that is, of course, part of this. But I will say too, it was also strategic, because we wanted local systems to actually adjust, right? That these are massive changes. Even if, for those who maybe are looking from the outside in and saying, well, why don't you have trained attorneys? Why aren't attorneys meeting with their clients? That seems pretty foundational. It should have already been happening. Yes, that's true, but it wasn't. We had, I think, 1 court or 1.5, like sometimes courts that would provide counsel at first appearance. It was a huge change all across the state to make this happen. It meant that attorneys had to get hired, that more attorneys had to be, put on rosters, that we actually had to put funding aside and actually teach attorneys how to use investigators and how to use experts. They had no idea. Many seasoned attorneys had never used such resources before. And so it took us quite a few years, from 2019 to today, 2024, to see all 9 of these standards get approved, get into place, and I'll let you know how the end of this year goes about implementation for standards 6 and 7. And I will put a note out there too. I mean, the reason why 6 and while they didn't go numerically, which is somewhat annoying, but that's okay. We put the workloads and review of counsel and qualifications last, frankly, because it's not so much just we need to raise compensation of attorneys out there, or that we need to systemically change, the court docket timing so that counsel can appear first during arraignments. These 2 standards mean that we have to address very large national problems that are about attorney shortages in rural areas that simply don't have enough capacity to attract people to the area to live, that we don't have enough trials to qualify attorneys to do the work, to take on capital cases. This is directly related to attorney shortages, and we tried along the way, when I talk about planning for the future, these developing and rolling out each one of these standards and all the technical assistance that we provided. Wrong side. Each one was a stepping stone to the next. Again, through the question we just had, but I just wanted to put out there that, we do have these guardrails. And the biggest way that I saw to get people to buy into this plan, to say, like, all right, we have these standards, we have to make a plan. Yeah, okay. We said it a lot that, if the funding doesn't come in, you don't have to adhere. You don't have to make all these big changes. You don't have to become a project manager locally. And that helps quite a bit. So I don't know if that's something that we see, some of the other states that I've spoken where they're worked with, this isn't necessarily always an option. But if there is something in there, whether it's statutory or, to kind of, again, this is like a carrot and a stick scenario to help convince local systems that, look, the sky is not going to fall if you start this project and it ends and goes away. And it was a huge, huge help. And so with all of that, this is I'm showing you, and so this is today's numbers, how we've grown significantly. With all of this convincing and all of the things that we've been able to do, we've actually gone from, so it was 86 million in the state share. Now these, the orange part here is all the local share in it. And again, it's about 38 million each year that the local systems have to always contribute. And that's the number they pretty much contributed on their own for years prior to us existing. But the state grants obviously have significantly risen over the years. And in our statute, we allow and encourage, like I said, we encourage innovation, but these are also minimum standards that we provide. So we expect, and the commission has improved every year, innovations that go over and above. One of the standards in our statute says that it has to be reasonably and directly related to public defense or indigent defense. That can be quite a few things. So, we've been able to, for example, with this funding, for example, we've grown public defender offices all over the state. We've grown managed assigned counsel systems all over the state. Some of our systems have regionalized together. Some of them are hybrid, PD offices and MAC offices. Some of them have regionalized if they're just district courts in a region. It's been all sorts of really, really great local innovation and flexibility and creativity. Working directly with our staff, who are out in the field and helping us bring this technical assistance to the local systems, but also helping them to convince their county administrations or their local, authority figures that, look, this is really something you should invest in because it works. And, and the state will help you and provide you grant funding for it. So that's why the funding increased every year. It doesn't mean it makes my job necessarily easier to come back to the appropriations and the appropriations commissions and committees and the legislature and state budget to say, hey, look, we need to raise the price tag. It gets harder and harder every year, but I will say that we've been able to kind of prove our work. So we're actually building all of these brand new things that our state can become proud of. We've built trial programs, simulation programs, holistic defense fellowships. We've engaged all across the board in terms of whether it's with our law schools, leadership conferences. We've gone down and helped create more mock trial teams in high schools. All the things that we can do to help build this community of public defense at the local systems, knowing full well that we have local partners on our commission, that we have local elected officials on our commission, and support from the legislature in those capacities. And this all makes a huge difference. That we're able to actually show, look at the wonderful things that you're doing for your communities and building up these best practices and becoming an example to be modeled. It works. It helps. So not only that, we're doing and building really great programs, we also have a very intense oversight process. And this is definitely a handful of years ahead and probably of where you are right now. And so not to kind of jump too far ahead, but these are the types of things that we really thought that we had to think about quite, within the first year of providing grant funding out there. That, look, if we're going to send hundreds of $millions out the door as state dollars, we have to be good fiscal stewards of the state money. So that means we have to provide very big, very broad oversight and with lots of detailed. We were very fortunate and still do have a wonderful grant director who was very familiar, came from our state court administrative office, who was very familiar with the court operations. Very lucky on that part. And we built into our grant contracts a very intense quarterly reporting. Our regional managers help out with it, ensuring the reporting comes in. Our research staff, we have an analyst who came to us from our legislative research division in the state, and he's very adept at knowing exactly what it looks like to have consistency and quality reporting and how to use that information that we get so that we're actually digesting it and being able to show the legislature that it's worth it. So we have quarterly reports. We constantly are reviewing the plans that are coming through, and we're matching. Now we're at the point, we're in our 7th year of granting. So we're finally at the point where we're actually able to look far enough back that, we can tell, like, okay, well, we're finally right sizing the amount of money that is appropriate. We're no longer just kind of having educated guesses on how much might you need for counsel at first appearance or how much might you need for new expert programming. We're getting much better every single year. And while we do not have administrative regulations, we do have policies that we've created. Our statute requires us to create them. They're public. They're all on our website. We have a grant manual. We've built into our grant agreement the various reporting policies that we have. The regional manager team and some of our leadership team, we do court watching and site visits all the time. I require of the staff that they're supposed to be conducted on all courthouse locations and all jails twice a year. So that's we have people all over the state. It's a lot of travel line items that we use for our budget. We also have graded rubrics that we've created to match up to our standards for compliance, so that and then we present them annually in our annual report, but also in presentations to the legislature and to the commission during public meetings. And then we also contract with an auditing firm, a CPA firm, to ensure that the money is being spent appropriately. And I mentioned we're at our seventh grant year. It took us a while to make sure that we actually are able to capture what's happening and not just capture data on quarterly reports on how money is being spent, but we also require quarterly reporting in terms of programmatic work. So we're able to actually tell you how many cases are actually being represented by public defenders, how many public defenders there are across the state. There are about 1,400, in case you're wondering. How many, things like these really cool stats that we're able to show that actually trial verdicts on felony cases are increasing, which is, you can read that both ways, but that means that advocacy is increasing, that public defenders are being resourced and paid for their time and actually being able to be more zealous in their advocacy. We see that specifically in counties that have offices that started in our early years. And some of these counties are really rural, very far up in our Upper Peninsula. Some are in our, couple of these are in prison counties that have high population rates that aren't necessarily super supportive of public defense. It's pretty cool to see. The interlocutory appeal rates went through the roof at 250% increase since we've started our grants and started resourcing public defenders. Again, these arguments don't always necessarily work for your legislative, but for those who actually care about public defense and the changing and the representation of folks, making sure that zealous advocacy is important, showing that its importance. There's no better way than just to show that, look at these things that are changing that never happened before. We've been able to now, at the point here, we're able to talk about the amount of, again, we've had about 1,600 cases where experts are used, which on paper, that should be almost every single case, right? But that's an increase dramatically from 25% from their first year. In Wayne County, which is where Detroit is, we saw a 280% increase in investigators. The sad sack is that, these are, big gaps that never existed, meaning that they definitely weren't used before. But it's still amazing to see. And we do support, while it's not a part of our standards, and these are things that we maybe are very likely looking towards in the future to adjust our standards, especially with the new edition of the ABA 10 principles that have been reissued. We support holistic defense programs, very, very, very supportive of those. In fact, most of our PD offices now that we support have either social workers or client advocates or something along those lines. We've actually even partnered, I think I mentioned before, we've created a statewide holistic defense fellowships for both social work and law students. These are things that our grant funding supports across the state. It's pretty cool to be able to see where that goes. And that helps us build a pipeline. Again, I'm just kind of going through the types of stats that we've been able to pull out, and also relying on national information. It helps to kind of to push that narrative and to make sure that, yes, we are relevant. We are doing good things. We've been able to show just anecdotally in local systems how important it is to build the client relationship, and that people are more likely to participate in the process. That certainly is a huge deal with a lot of our judges who like to see the client show up and be a part of and present. And then one of the things, lastly, we're very fortunate to have some help with a PhD research student who was able to actually focus on one of our public defender's offices to show that actually for every dollar spent on hiring a new PD attorney, that we were able to save money in incarceration costs by reducing caseloads. I mean, to be able to actually say something like this is pretty great. There's a lot more research that can go into it, but it's definitely an angle, especially the angle here too about, our budget is a drop in the bucket when you compare it to, say, the Department of Corrections or state police. Again, because we're still so new, people don't really think of us like that. It's certainly on our state, but it's, again, we're in our 7th year, and I'm hoping and pushing for that narrative to continue to change. And then lastly, I'll there's a lot. It's not like we're done. We have a lot left to do. One of the things that is glaringly missing, and I believe in Pennsylvania that's not the case, which is great, and I applaud you for it. We have no standards for youth defense. Right now, we have a bill that out there that would help us expand, but and that'll change quite a bit in terms of my staffing and start the process over, frankly, in terms of creating new standards and altering what we have. And so there's a lot of things out there to do. But I just, threw up these things that, we're now in a phase where it's, we've been able to use data we've collected to tell a story, we've educated, but we've also gotten into the compliance phase of things. It's been a long 7 years, and I feel very, very fortunate to where we are in this place. So now we can start addressing things like long-term investments for pipeline projects, student loan forgiveness ideas, training, programming, leadership developments, all these types of things that, for the first couple of years when we just simply had to figure out how to create a grant management program or what standards next, we really couldn't focus on this. And so we're in a nice spot at the moment to look towards the horizon. So, and there's a couple of questions that come into the chat. So please, I'm going to stop here and maybe actually stop sharing, or let's see. Also, people can feel free to take the mute off if they want to just ask, but I'll read here. So on the training, there are measurable benchmarks at how this must be achieved and done. Yes, I believe you're talking about, how do we track our training and how things, we do have training standards. So that, let's see here, I'm going to stop sharing. Our commission has created standards for what trainers, the qualifications of trainers. We also have policies on the types of trainings that are allowable for CLEs. They can't be any longer older than 3 years old without coming to our commission and getting approval. We have a committee of our commission, a training committee, that must approve anything that's a certain year old. It has to be relevant to public defense work. We're pretty flexible because we want to encourage training, but our training director has been given permission from our commission to actually kind of be the person who oversees CLE. It does have to get done within a 12-month calendar year. And we're pretty serious about that. We've definitely seen systems who have taken people off the roster list until they complete the next round, because it's one of our standards and we mean it. So, there are some caveats within our standard that allow for things. But it's, that's one of our benchmarks. And so one of the biggest ways that we show is that when people are trained, we're actually able to see the outset. So, whether it's the amount of, it's more anecdotes at this point, but we're able to show with the training hours increases, and we try and compare that as much as we can with, certain benchmarks of, like, maybe it's trials conducted or, other things at these locally, but we're still working on that. Let's see here. Budgetary considerations that cover anyone beyond the attorneys on staff, their advocacy measures in place to ensure staffing. Yes, all of these things. So we don't receive funds. So none of this money actually comes from it's the opposite. So our funding comes from the state. We're the grant administrators, goes out to our local systems. Yes, and we absolutely, in terms of advocacy measures, yeah, we absolutely work with our advocacy community. That is my background, public policy work. So, it's not too surprising to make sure that we're reaching out with our local people who are actually pushing boundaries of certain issues. One example, for example, is making sure that we can expand into working in the youth defense world and make sure that those constitutional considerations are being upheld as well. We're absolutely working with folks, whether it's our ACLU or our state bar, a couple of other public policy and criminal justice advocacy units out here. Yeah, but the funding, is 100% from general fund from the state of Michigan. So that does scare some some folks, myself included. And on my little to-do list there, which is not very little, is to how to make sure we keep this sustainable. We do have a mechanism built into our act that created what's called an Indigent Defense Fund. So but it's been empty since it's been created. So we don't, for example, collect tax dollars or, funding that, comes from lottery tickets or liquor sales or anything like that. We, some of our other programs do. Our education program, for example, is something like that. But that is a big to do on my list. Let me tell you. But for now, we've been going okay, and a big part of ensuring that this works, that we're continuing getting funding, is showing the benefit of the community, and it doesn't hurt too that these are constitutional rights, and state has a mandate to fund them. So that certainly is something I talk about. Hope that answers this. Let's see, Sarah. Process of using creating anyone standard topic. Yeah. So yes, all of the above. So when we picked, well, I will say, so I started as a director. There is a director that was between Jonathan and I, by the way. So it wasn't just us, but there's been three of us. So Lauren Kogali, who's she was here for about 2.5 years after Jonathan and before I came on as director. She's now our head of our ACLU. So again, great partnership. Who knows quite a bit about what we do. Yeah, and during that time, what happens, we had public hearing. We would always receive feedback. We would also have to have public comment processes, not just from the commission, but also once it was up for approval at our executive branch agency level. We also then again held it for public comment period. We really, bulletproof is the right way to say it. We wanted to make sure that, if anyone had any comment or any thought, now you must say it now, because it's so hard to go backwards and open these back up. Not to say that we aren't possibly planning on doing that, but we wanted to get as much input as possible. We also were able to, like I said, strategize about putting forward one standard versus the other one. I knew, for example, the standard on attorney payment was going to cost a crap ton of money. Frankly, it is it already at this point has that standard alone cost us around $96 million just for one standard, because our attorneys were that unfunded, and that were that poorly compensated across the state. And so that's a big thing to swallow, especially since that costs more than that single thing alone, but costs more than the first 4 standards together in the first year that we're given. And it's a continuing amount of money. Our standard requires that COLA costs are incorporated. So it's not like the money is going to stop, but you get paid 1 year. People have to be paid every single year. So we strategically waited on that one. And we strategically, for example, waited on these last 2 because of pipeline issues, of recruitment and retention challenges. Which, thank you for that question. Yeah, I mean it's a real problem, and it's not just our problem. It's not it's a national issue. I know some states out on the West Coast, for example, attorneys have just stopped, and honestly, there's a really good argument for why that happened. There's ethical concerns of overworking and not being able to actually prioritize the client in front of you. So it's a really, really difficult balance. Thank you. Great question. Yeah, I mean, it's hard. And this is, so one of the number one thing that my training director and a lot of our local, our training partners across the state focuses on are attorney well-being. We actually have, our Supreme Court has a well-being in the law commission that they just started. We are a partner on that commission. A big part of it is, how do we actually, focus on the burnout and bring people back into the work, try and recruit folks from, students that are coming up to become new attorneys, my own personal story, right, is I'm not originally from Michigan. We moved here about 15 years ago. And when I first moved here, brand new attorney, ready to do the work, had been working in a little bit in Kentucky in public defense. And I thought to myself, cool, I'll come up to Michigan and see what public defender offices are hiring, and if we can get into the work. And it's like comical, that didn't exist. There weren't any offices. There was nothing here. And so for many, many years, if you were a law student coming out of Michigan's 5 law schools, you didn't stay in the state to practice public defense. Or if you did, you were so underfunded and so poorly treated that, you didn't stick around. Or if you did, all these like awful things. So we have years of things to break down. Yes, it helps tremendously that we have these standards in place now. People are getting paid well. Trainings are occurring. We're building community. And that's a big role that we play. We've created a defender leaders group with its own listserv that brings together all the public defender chiefs and their deputies and the management assigned council administrators. We have monthly brown bags. We have defender leader trainings. We specifically do an Upper Peninsula or UP training every single year, just because we want to focus on our rural community, or our rural practitioners. I mean, they're very isolated, but we want to make sure that they're connected as much as we can be. We support programs. One of our newest initiatives that we've been supporting is called the Special Assignment Team, which is pretty cool. So it's really a kind of a matchmaking program for those places that are having major shortages because of maybe conflicts, or just attorneys aren't available, or it's a massive in need of co-counsel. One of our rural counties had it was like a 10-person co-defendant case. It was a terrible, like a meth case or something along those lines. And so, how do they find these attorneys and match them across the state? So this is, truly, we bring people from Detroit area, metro area up north and temporarily assign them. And they get paid their travel, and they get to see other parts of Michigan, and they get to do the work, and then, go back to where they don't have to stay, and they don't have to move there. They just need to temporarily take the case. And that's a huge help. We're trying out anything that'll work. So it's like a living document. We're trying it all right now.
I'll add a couple of quick things
Please do.
to those last 2 questions. Sarah, the one about the process for developing standards, I'd say there's a formal process and an informal process. So the informal process is sort of for our first standards was internal and developed by the MIDC and by staff. That was very much surveying. That could be everybody from judges who we had good relationships with, who we knew were engaged, to defense attorneys and public defenders who were active in Michigan, but not necessarily part of that commission staff, to folks who were head of different criminal legal system reform groups. And then we would gather data and look at other states. So that was all what we did internally. And then externally, more formally, that Kristen alluded to, the statute set up a process for public hearing and a comment period. There was a certain amount of days, and then that comment period happened twice, once during the development process and then once during the LARA approval process. So we had sort of one piece that was set in statute and then one that we set ourselves. And then on the recruitment and retention question, I'll just speak from my experience at the State Appellate Defender Office, and I'm sure the folks who are here from the Philly Defender and other good offices in Pennsylvania, I mean, we really find that nothing is better for recruitment and retention than being able to keep workloads under control, having folks properly compensated for the work they're doing, and just creating that sort of culture is our best ammunition for recruitment and retention, for sure. And so the MIDC, through all the processes Kristen has talked about, is starting to have success in pushing that to other offices and as a statewide priority. Sorry, Jordan.
Good.
No problem. I just had a quick question, and I'm sorry if I missed this. There was a lot of really great and important information shared. But Jonathan, early on, you had talked about the separation of power issue that had come up and how the law was changed so that the Supreme Court was no longer approving the MIDC standards. Is the Supreme Court involved in any of the current commission processes now?
the Supreme Court has a non-voting member on the commission, and I think that's it. Kristen, do they appoint any of the commissioners?
Yeah, there is a seat. So each, yeah, the Supreme Court as a whole gets a seat, and the Chief Justice has. So the Supreme Court does nominate a seat. She's actually our vice chair, right now, and the Chief Justice has an ex officio seat, and so typically she doesn't actually come. She nominates and sends over the court's legal counsel, who participates for sure, just doesn't have a vote. But we do also have seats dedicated that are voting members from our Circuit Court Judges Association and our District Court Judges Association. So they're very much involved. And we, the administrator, the current administrator of the Supreme Court used to be one of our commissioners. And so he's very thoughtful about including the MIDC and public defense partners on all the things that the court is doing. So it's we're very much a partner of them.
Thank you.
Yeah, good question. I also feel like I ran through a lot of information too. So it's, if there's any other questions, and the slides are yours to have, to follow up with any questions you all may have. But yeah, this is great. You have a lot ahead of you. So don't feel like, there's a lot of, no need to reinvent certain wheels. We've definitely over the years made some mistakes and learned we just learn through the process. It takes a lot of patience to get these standards developed and out the door and get the funding and the support and the staff and the resources. But it's doable.
Well, we really appreciate your time and being here and offering to serve as a future resource. It is an exciting time in Pennsylvania to be getting into this. I want to say though, for folks who are here, other questions for John and Kristen while we have them here. I think I saw another one come in here into the chat.
Yeah, so I can field that one, Cheryl. Great question. So there's a lot of local control in what we do, right? So we have 133 systems, and each one is slightly different. They have to adhere to our minimum standards. They can go over and above. They can have a PD office. They can have a managers on council. They can do, so yes, we do have now. Again, this goes to our caseload standard that's being unveiled this year. We are counting the amount of indigent defense cases an attorney has as part of our standard. We don't really have capacity at this exact moment to be able to count how many cases a person takes, whether it's retained or non-criminal defense practice, or something along those lines. So for example, if they take juvenile cases or if they do neglect and abuse, these are research issues that we know that we have to tackle. And so this coming year, we will be building up like infrastructure to be able and putting out support and funding to our local like managed assigned counsel administrators or PD offices that track the amount of cases. But for now, yeah, and it's not as though they're not allowed to, but they have to make sure that each system has to make sure that their local attorneys that they utilize and they employ aren't going over the caps, and so that's a huge deal for us. And the caps, by the way, we have the old NAC standards. Just by in our standards, it's yeah, I know. So again, we have a lot ahead of us. So it's 150 for felonies and 400 for misdemeanors in our standard. It's clearly not the national standard anymore. Since you all had Malia here last time, that's the case. We know that's the case, but it's what we have right now. So we do expect in the years ahead of us to go back and alter this and reassess. They have to. So what do we do to ensure the compliance part of it? Great question, Kate. So if you are accepting an assigned case, when I say public defenders, I mean the broad umbrella. So that's my language. I'm sorry. If you take an assigned case, if you accept an assigned case, you have to fall under the CLE standard. It doesn't matter if you are employed full-time at a PD office, if you are on the roster full-time, part-time, if you are second chairing or if you're randomly selected to take a case once in a while, you have to get your CLEs in, and you have to fall under that standard. So if you are going to be employed by that county, that local system, and you're not adhering to those standards, then we will come in and start our non-compliance process. And to ensure it, we start that's our compliance process that we go through every year with our rubrics and on-site checks and things like that.
I'll add just briefly to this, Kristen, you had mentioned data and reports. I'll commend everyone to the MIDC's website where they have all kinds of reports. They have all kinds of data available there. I got to say, I'm really excited that you have that stat about every dollar spent or every public defender hired saving corrections dollars, and that's
it's huge. Yeah, so no, and it was a study that I'm happy to share. It's linked also in the slides, but it wasn't just Michigan. It was a couple of sites across the state. It was one. There you go. It was a site in Ohio, I believe a site in Oregon, and one other place that I'm forgetting. But it's they were able to study and actually show that look, you save money because you're reducing caseloads, and so you can focus more on your client ahead of you that's right in front of you, and you're reducing pre-conviction jail time and detention, being able to get a person out on bail easier, all that kind of stuff that's happening. Mm-hmm. That's how it's connected.
That's great.
Yeah, sure.
So we have one last question here in the chat. I'm going to call this the end so that we can let folks go and let Kristen and John go. It's what concerns do you have with sustainability, if any? Do you foresee a lack of buy-in that would make this funding or programming subject to ending if money stops being provided through grants? I'll say this is a big concern in Pennsylvania because our grant pool is so, I won't characterize it in size because it is what it is. It's $7.5 million and we're grateful for it. But because it's so new, county commissioners are like, I don't know that this is going to keep happening. And I think this question kind of reflects that reality here.
Yeah, it is. I think this concern has always been floating there. From my perspective, and I'm sure it was a different, Jonathan, when you started, I'm sure that sustainability was always there to it. But yeah, no, this is literally what kind of keeps me up at night sometimes. I'm not gonna lie. The numbers are big. I know we cost a lot of money, and our commission has supported so many wonderful things and innovations, and we've been able to grow and really show that it works and truly. And that's the angle that I've strategically taken to say, like, look, we've grown this and it's too important to not fund. But that provision still exists that if you don't fund it, you don't have to do it. I feel as though we've grown so many roots across the state that we've built so many, 40 some offices, and they're still growing, and we employ the funding it's this year's funding is $258 million that goes not to us, not the state office, but out to the local systems across the state. 80% of that is for people's direct salaries or our pay rates. 80%. So that funds people. It's funding attorneys, social workers, investigators. We're not funding paper clips. It's not, we're not like doing construction projects, although we have funded like build outs of offices and confidential meeting spaces and jails. But those are one-time costs. These are just like if you're a state employee, I mentioned you get COLAs every year. You get, it costs a lot to have good quality people on staff doing the work. But sustainability is a real big issue. And I think if I had a witching mirror, or like whatever, my magic 8-ball, I would expect to see some type of more hybrid state growth, something similar where there's like maybe a state like regional office, very, very similar to our pellet system, where there's an actual state law firm office that provides direct service. But then we still have local entities that are able to be innovative, because our upper peninsula counties, our rural counties are not Detroit, right? And vice versa. And they have different needs and they should be treated differently. But yeah, I think that'll probably be, and there is a lot of efficiencies that can be, you know, you can cut costs, right? And it's true. And I hope that won't cut down on innovations, but there are certain things that don't cost a lot of money. Our training programs only cost $1 million a year. It's the cheapest thing that we do, and by far does the best, you know, sustained level of change. So out there. Jonathan, I don't know if you want to add anything. Sorry, I kind of.
Yeah, I mean, and I know we've talked about this. I mean, that it is the fear, and it doesn't go unnoticed that the overall cost keeps going up. I do think over time the MIDC, and it's not so much a statutory mandate, but hopefully there'll be a recognition that by the legislature and the executive that the MIDC has a role in saying, all right, we've been doing this for a while. What are the best systems and what are the best practices, and how can we start to duplicate this rather than this complete local control system where 125 different places may, as long as they comply with minimum standards, have all these different compliance plans. And the MIDC hopefully will be able to shift to a point where they can take the lead and say, look, we need a regional defender office here, and we need a state defender office here that excludes these 20 counties so they can have their own city public defenders. And I think as the MIDC can move towards that model, they can make a case saying this is not only the best delivery system, it's also the most efficient delivery system. Whereas right now, it's amazing that the state has made this commitment, and it's night and day from the quality of public defense before, but it may not be the most efficient way to go. And the MIDC is well placed to move it in that direction. So that's the hope, is something like that will be the response to the sustainability questions rather than, oh, we're going to start cutting funds or something along those lines.
Yep.
Thanks for having us. This was awesome. Please reach out anytime.
Anytime.
Yeah, we absolutely will. John, Kristen, thank you so much for your time and for sharing those materials with us. Really, really appreciate it. Can't thank you enough. It will help us do our work better and faster, right? To learn from the guidance that you all give us. Thanks to everybody who joined us. As a reminder, this is recorded. We're going to post this on the PCCD website, and we will make sure it gets out to folks, including all the slides with the great data points, all of that. Next up for us, again, it's going to be getting into the work of the subcommittees, the data subcommittee meeting this Friday, standards subcommittee meeting Tuesday, October 8th, and training committee meeting first, October 22nd. We're still doing a little recruiting for those. We could still use some input from, say, folks in the northern part of the state. Still could use more attorneys of color. People of color, actually, doesn't have to be attorneys. So if you know of folks who would be a good fit for this, yeah, we may still be able to slot some people in depending on those needs. Again, thank you all. Appreciate your time, John. Appreciate you, Kristen, as well. And Jordan, thank you always to you and everybody at PCCD for running the webinar. Thanks, everybody. Have a good day.
Thanks all.
Bye.